In the aftermath of the attack, the Justice Department began its work on what has become one of the largest, most complex, and most resource-intensive investigations in our history. Only a small number of perpetrators were arrested in the tumult of January 6th itself. Every day since, we have worked to identify, investigate, and apprehend defendants from across the country. And we have done so at record speed and scale in the midst of a pandemic during which some grand juries and courtrooms were not able to operate. Led by the U.S. Attorney's Office for the District of Columbia and the FBI's Washington Field Office, DOJ personnel across the department in nearly all 56 field offices, in nearly all 94 United States Attorney's offices, and in many main justice components have worked countless hours to investigate the attack. Approximately 70 prosecutors from the District of Columbia and another 70 from other U.S. Attorney's offices and DOJ divisions have participated in this investigation. So far, we have issued over 5,000 subpoenas and search warrants, seized approximately 2,000 devices, poured through over 20,000 hours of video footage, and searched through an estimated 15 terabytes of data. We have received over 300,000 tips from ordinary citizens who have been our indispensable partners in this effort. The FBI's website continues to post photos of persons in connection with the events of January 6th, and we continue to seek the public's assistance in identifying those individuals. As of today, we have arrested and charged more than 725 defendants in nearly all 50 states and the District of Columbia for their roles in the January 6th attack. In charging the perpetrators, we have followed well-worn prosecutorial practices. Those who assaulted officers or damaged the Capitol face greater charges. Those who conspired with others to obstruct the vote count also face greater charges. Those who did not undertake such conduct have been charged with lesser offenses, particularly if they accepted their responsibility early and cooperated with the investigation. In the first months of the investigation, approximately 145 defendants pled guilty to misdemeanors, mostly defendants who did not cause injury or damage. Such pleas reflect the facts of those cases and the defendant's acceptance of responsibility, and they help conserve both judicial and prosecutorial resources so that attention can properly focus on the more serious perpetrators. In complex cases, initial charges are often less severe than later charged offenses. This is purposeful, as investigators methodically collect and sift through more evidence. By now, though, we have charged over 325 defendants with felonies, many for assaulting officers, and many for corruptly obstructing or attempting to obstruct an official proceeding. 20 defendants charged with felonies have already pled guilty. Approximately 40 defendants have been charged with conspiracy to obstruct a congressional proceeding and/or to obstruct law enforcement. In the months ahead, 17 defendants are already scheduled to go to trial for their role in felony conspiracies. A necessary consequence to the prosecutorial approach of charging less serious offenses first is that courts impose shorter sentences before they impose longer ones. In recent weeks, however, as judges have sentenced the first defendants convicted of assaults and related violent conduct against officers, we have seen significant sentences that reflect the seriousness of those offenses, both in terms of the injuries they caused and the serious risk they posed to our democratic institutions. The actions we have taken thus far will not be our last. The Justice Department remains committed to holding all January 6 perpetrators at any level accountable under law, whether they were present that day or were otherwise criminally responsible for the assault on our democracy. We will follow the facts wherever they lead.